I'd like to move along if we could to look at the local laws and ordinances. And Richard and John, just get your input as to, we'll start with the town of Cape Vincent and our local ordinances and comprehensive plan. Could you comment on areas that you feel that you would ask the siting board not to apply? When I say areas of the law, or specifics of the law that you would ask the siting board not to apply.
So when we submit the preliminary scoping statement, we will have a list of laws that we think that we will potentially be asking the siting board not to apply.
Potentially or actually?
Well, potentially. It'll be that it will encourage a dialogue over which laws can ultimately be applied and which laws can't. But I think to go through them, generally I think we have section 3.4, which has a certain lot requirement for acreage minimum, frontage minimum, setback minimum, maximum height. Section 3.5. Wax are not a permitted use in a light manufacturing district. So to the extent we have any turbines in a light manufacturing district, which I don't know if we actually do or not, that's when I say like potentially we may get to a point where we don't trigger that provision of your law at all because there's no facilities or infrastructure in that district. Section 4, lot uses. 4.1, there's only one principal use per lot permitted. Accessory uses must be compatible with principal use. Your table 8, which is basically requires a special use permit in the agricultural district. Section 5.3, which delegates, I believe, to your zoning board of appeals provisions that allow those zoning boards to impose special conditions. Section 6.7, your noise requirements.
Give me specifics there.
Your decibel requirements and your enforcement mechanisms. So 6.74 and 6.7.6. And then there's section 7.16. All structure applications.
Specifically what?
Within this section, there's several at this point that we've identified. Again, some we may apply, some we may not, just for purposes of being overly inclusive. So we've got 7.16.4.D. Requires a certain paint, which we may be able to comply with, we may not. I would expect that to the extent it minimizes visual impacts, it's going to be something that the Article 10 Siting Board would also be looking to apply. 7.16.4E, G, H, J, L,
O.
and P. Some of this is a little bit redundant, but 7.16.10.
What is that?
Site plan approval and special use permit required for Lex. Section B, C,
I'm sorry, section EC of what?
sorry, of 7.16.10.B. And then also C of that same section, F of that section, G, H, and J. But again, I just want to highlight that within each of those provisions, there are portions that we will comply with and there are portions that we won't. So it's not a zero-sum game, it's not all or nothing. There's one provision within, one word within a sentence that we can't comply with. I've listed it here. It doesn't mean it's all being thrown out.
Well, I'm assuming you were going to give us a printout.
We can do that.
List that you
Yeah.
got right there.
Again, with the awareness that this is going to be
It's not
a
set in
work in
stone by
progress.
this part, is it?
So this is the preliminary assessment of,
of provisions within the zoning law that wouldn't
okay.